Since Edward Snowden first made his allegations against the United States government regarding its alleged surveillance activities, there's been significant legal, regulatory, as well as press coverage and attention on those issues. That's most recently culminated in the second decision from the CJAU regarding data transfer to the U.S. And in a series of slide casts, we will examine a variety of issues related to that, starting with an overview of the surveillance regime in the United States. Schrems II recently came out and has really given us a marked departure from prior views on standard contractual clauses or SCCs. Obviously, one of the key things with Schrems II is that Privacy Shield itself was invalidated, so we no longer have that transfer mechanism to the U.S., but SCCs obviously apply in a broader sense across the globe, though this case was certainly focused on United States government activity. Where we sit right now is it appears that additional factors must be considered in connections with SCCs by the data exporter, and practically speaking, I think that will mean that data importers will have to be able to address new requests from data exporters to try to figure out where and when SCCs can now be used, because it obviously is not as pro forma a mechanism as it might have been in the past. Again, this presentation will focus on the surveillance portion of the analysis, which was a key part of the CJAU's recent decision regarding this case. What the CJAU appears to have done is place the burden of assessing adequacy for a particular transfer of data on the data exporter, and obviously this references Article 45(2), which is a standard the European Commission uses. There are a variety of factors here that are, again, beyond the scope of this particular slide cast, but one key to look at is the rule of law regarding human rights, fundamental freedoms, but key here is national security, criminal law, and access of public authorities to personal data. When we look at surveillance authority in the U.S., we have to start with the scope and the deconfliction of presidential power. And you'll see page references in this slide cast. Those are to an accompanying white paper that will be available to sort of provide more detail about these issues. But there's sort of three categories of presidential activity. One is where the president acts consistent with the express or implied intent of Congress. And this is the point at which the president acts with the most power of any other area of power that the president may have. The second is where the president acts where Congress has been silent, which is a middle ground approach to presidential power. And the third is where the president acts where Congress has taken a position that the acts are improper. And there you have conflict between two independent branches of government, each of which derives power from different portions of the Constitution of the United States, and that is where the president acts with the least power. As we'll see, in many cases, we are dealing with Category 1 or Category 2 for surveillance, which does give the executive branch, acting really in the stead of the president, significant power to conduct surveillance in the United States as well as abroad. Congress in the United States derives its power from Article 1 of the Constitution, and so here we see Article 1 delegations. So these are areas where the Congress has delegated power essentially to the executive branch, and while we focus on 215 and 702 because of Edward Snowden's allegations, there's a variety of other laws that impact this, and so FISA is obviously one of them. FISA is not, as many people believe, a law that was enacted post 9/11. In fact, it's been around since the early 70s. It's been amended significantly and certainly was amended in the aftermath of 9/11. But it is a law that has been on the books for a long time. You do see the National Security Act of 1947 as well, the Patriot Act, which was a reaction to 9/11, as well as a variety of other reforms to try to streamline U.S. intelligence gathering and processing of data, which include two acts in 2004. And so when the president does act, he certainly can act pursuant to FISA authority, and within the president, I include members of the executive branch. But that is not certainly the only authority the president may have in this space, though we'll focus on FISA and 215 and 702. As noted earlier, the president has his own separate authority, and that is Article 2. And so you see here from two cases from the early 70s that recognize that, particularly uh, when dealing with foreign nationals, the courts have held that the president may constitutionally authorize warrantless wiretaps for gathering foreign intelligence, and that's particularly true where you're dealing with activities of a foreign power. So, even before the amendments to FISA that have caused some of the concern, there was broad inherent presidential authority to do some forms of warrantless surveillance, again, independent of the Article 1 delegations that Congress has made over the years. So what does this really mean? Well, graphically, when you look at the total surveillance authority of the president, you have Article 1, which feeds in to the extent Congress has delegated power, as well as the inherent Article 2 authority. And so if we think of the blue box as the total, the blue box is more than just Article 2. It's a summary of the president's powers, as well as those that have been delegated to him or the executive branch. Then when we look at delegations, we're sort of taking that same blue box and then pushing those down into separate channels. And so one thing that was discussed in Schrems II were a variety of different authorities and techniques. FISA, as we'll talk about, involves a U.S. person, which is defined in FISA, or it's a collection that happens on U.S. soil. There was discussion in the case about 12333, which is an executive order, and that is an authority that is not typically supposed to be used for a U.S. person, and the collections are done not on U.S. soil. And so one thing to note here is the context of obviously this case is data transfer from the EU to the U.S. from up with a private company doing the data transfer. And so inherently we're talking about a collection that is happening on U.S. soil, and so candidly, 12333 is not really the focus of the surveillance authority that in all likelihood would be used for a collection because FISA and perhaps others apply. Now, one thing that none of us know is what other authority is out there. Obviously, the president, as noted in the prior slide, does have inherent authority to do certain forms of warrantless wiretapping, and those programs are frequently not disclosed. And so what we are focused on, again, because of public disclosures, is what was being done really under 215 and 702 of FISA, though 12333 and other authorities were at least discussed in the case. But to its core, the case is concerned with collections on U.S. soil that involve non-U.S. persons, because we're obviously talking about Europeans rather than U.S. persons. When we look at FISA, obviously, as mentioned, we do have 215 and 702. 215 was a bulk collection where data really that wasn't necessarily communications based, but was more about the types of communications and with whom communications were had, was used to really do a bulk collection. 702 is a much more targeted collection in the sense that it typically seeks content rather than just information about communications. As I noted in the prior slide, FISA is really directed at two things: the collection of foreign intelligence involving non-U.S. persons, where the collection occurs in the U.S., and collection of foreign intelligence regarding U.S. persons. And so what spins out of that is there are different standards used for these collections, or to use a U.S. term, probable cause. And so the standard for collecting against a non-U.S. person on U.S. soil is lower than it would be for a U.S. person. And this in part does really relate to the fact that U.S. persons would have Fourth Amendment rights. Non-U.S. persons, even if the collection happens on U.S. soil, really probably don't. And so as we're looking at some of the concerns that have been expressed by the European regulators, there is a different standard, and that standard is not the same across all people. There are lines drawn. One other line that is important is one that has been sort of disclosed in the press and now acknowledged, which is upstream versus downstream. And you'll hear the word PRISM used as well. Upstream targets companies that are part of the telecommunications backbone. PRISM or downstream targets companies under 702 that are not part of that backbone. And so the type of collection that goes on under 702 includes both, and they certainly were different programs, and how those are implemented obviously is in many ways fully classified, but we do know that there are differences in sort of which types of companies are targeted under which particular part of 702 on these programs. Again, just to offer some clarity regarding 12333 as companies look at surveillance here. One of the positions that was taken in the Clapper case, which was litigated pretty deeply through the U.S. court system, was the position that the Department of Justice took, which you can see here, which is that 12333 provides an independent basis for surveillance, including human and technical collections undertaken abroad. And so when we look at surveillance and what issues that may raise under standard contractual clauses, while 12333 certainly does speak to surveillance overall, it really probably doesn't speak significantly to collections that happen in the U.S. for this very reason. One other thing you'll hear about is PPD 28, which is a presidential policy directive. It does apply to collections under FISA as well as other forms of collections, including abroad. It does not have perhaps the level of restriction built into it that, frankly, some of even the new FISA requirements do, and that in part is because it does involve collections that are not undertaken under U.S. soil. And one of the things that you will see with surveillance laws, we dig into this deeper, is overall protections are at their height when you're dealing with a U.S. person on U.S. soil. And anytime you change either of those variables, the protections tend to be lower, including if the collection is on U.S. soil with a non-U.S. person. And so that is certainly part of what was analyzed in Schrems II, and that distinction was one that was drawn both on remedies, which we'll talk about in a different slide cast, as well as sort of the protections and the guardrails, if you will, around FISA in particular. One other thing we'll just mention, and it relates to gathering of information, including about surveillance, is FOIA. FOIA is a mechanism to gain information from the government. There are, however, a number of different exemptions from FOIA, one of which is obviously for national security, one of which is for ongoing criminal investigations. And as we'll talk about, sometimes the lines between a national security counterintelligence investigation, for example, and a criminal investigation can get very blurry, and information can be used for, frankly, one or both. And so we do also, one thing that has gained a little attention over the years is there are times where the intelligence community in the United States will not respond with a denial to a request or, frankly, affirm something, and they will instead give a GLOMAR response, which is they will neither confirm nor deny any sort of give a response other than saying they will neither confirm nor deny that a program exists or that certain surveillance activities were taken. And so part of this goes obviously more to the remedy side, which is how does one receive a remedy if you can't figure out you were surveilled? There are ways to address that, but that is certainly something that was discussed and raised in the Schrems II case. So when we look at this, to give this sort of final context, the court expressed concerns over the surveillance regimes in the United States that were sufficient to doom, frankly, Privacy Shield. However, SECs were not categorically held invalid. And so the point of this is to provide an overview for your company as you look at sort of what the landscape is here for surveillance and how one can look at this and at least understand at a very high level what the relevant authorities are and again what what processes or controls are in place. Again, this is a very complex area, and we'll be providing more detail on it in the future, as well as future white papers. But as an overview to understand the context of the Schrems II decision, this is really the core things to start thinking about as you try to address it. So we will be back to you with more information, I'm sure, in the very near future. And thank you for your time and listening.